Clarifications, please. Mr. Chris D'Souza.
I'd like to thank the Senior Minister of State. I saw quite a thick file, and if there's anything more SMS would like to say on skills future, legal technology use in Singapore,
clarifications, not an excuse for extra speeches.
In addition to those clarifications, Mr. Chairman, the use of SMC, I think, is very positive. But at the same time, where we have a lot of cases settled and the settlements are kept confidential, it does impact the development of legal jurisprudence in Singapore. So would there be, in addition to the clarifications that I asked previously, would there be a move to encourage parties who do not mind having their settlements non-confidential in nature, allow for the mediators' understanding and grounds in coming to his conclusion or her conclusion published, and quite possibly published as a judgment of court or a decision of the SMC? Thank you.
I think the member's question on mediation, most mediations, and I think Mr. Sito's own experience has been the same, are private and confidential for a number of reasons. People choose to look at a dispute from different angles. And mediation allows you to explore a resolution of the dispute on means which are completely extra-legal, on different considerations, such as commercial considerations or maybe confidentiality considerations. So it might not necessarily add to legal jurisprudence to have those mediation agreements published. But I understand Mr. D'Souza's point. I mean, on those cases where there might be legal jurisprudence, there might be legal merit in doing so, with the consent of the parties, obviously, and the mediators, that can be considered. On Mr. D'Souza's first point, and I welcome that because it gives me an opportunity to explain this a little bit more, we do see development and upskilling of know-how, competencies as a very important part of legal development. We have to make sure that our lawyers who come out from law school and those who come out from their practice traineeship are properly equipped for practice. And Mr. D'Souza knows that we've been looking very closely at what we do with practice traineeship, and the committee has given a very extensive discussion on that. On top of that, those who are already in practice, either as lawyers or those who are now serving the legal fraternity as paralegals or other support professionals, there must be ample opportunity to upskill. And we are very glad to be working with Skills Future and the Academy of Law as well, in having a broader and more diverse mix of opportunities available and supported by Skills Future, so that these individuals who are already in the system can upskill themselves and enhance their career opportunities and overall lend to the improvement of the legal landscape that we have. Thank you.
Any other clarifications? Mr. Chris D'Souza, would you like to withdraw the amendment?
Mr. Chairman, sir, we have had a productive debate, first starting on Friday and then now concluding on Monday. I would like to thank SMS Edwin Tong for his comprehensive responses to our cuts. Sir, Singapore continues to have an efficient and effective governance system based on the rule of law due to the hard work of many players in the legal industry. These include MinLaw, IPOS, IPTO, and many other public officers. So, in conclusion, a big thank you to the Minister, Minister K. Shanmugam, SMS Edwin Tong, MinLaw, and the officers for their hard work. With that, Mr. Chairman, I beg leave to withdraw my amendment.
Is the honourable member given leave to withdraw the amendment? I think leave of the majority is given. The amendment is withdrawn. The question is that the sum of $269,697,500 for head R stand part of the main estimates. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that the sum of $323,398,500 for head R stand part of the development estimates. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.